Distinguished guests, ladies and gentlemen, please be seated. Distinguished guests, ladies and gentlemen, the ceremonial opening of the Sabah and Sarawak legal year 2026 will now commence. Please rise and join me in welcoming the processions of the court orderlies. processions of the Chief Registrar and Registrars of the Court. The processions of the High Court judges and judicial commissioners of the High Court of Sabah and Sarawak. The processions of the Right Honorable the Chief Justice of Malaysia, the Right Honorable the President Court of Appeal of Malaysia, the Right Honorable the Chief Judge of Sabah and Sarawak, and the Right Honorable the Chief Judge of Malaya. And now, the national anthem, Negaraku, followed by the Sabah State Anthem, Sabah Tanah Airku, and the Sarawak State Anthem, Sarawak Ibu Pertiwiku. Thank you to the court choir. Please be seated. The court choir was led by Tuan Aidil Putra bin Haji Alwi, Senior Assistant Registrar, Office of the Subordinate Court of Sabah and Sarawak. We invite Tuan Hurman Hussein, Session Court Judge of Kota Kinabalu, to recite the doa.
Let us bow our heads and begin our supplication by reciting the mother of the book, Kitab, Al-Fatiha. Bismillahirrahmanirrahim. Alhamdulillahi Rabbil Alameen. Wassalatu wassalamu ala ashrafil anbiya wal mursaleen wa ala alihi wa sahbihi ajma'in. In the name of Allah, the most merciful, the most beneficent. Praise be to Allah, the Lord of all worlds, and peace and blessings be upon His most noble Prophet, Muhammad, and upon all His family and companions. Allahumma ya Allah. O Allah, we do call upon Thee. O Allah, our Lord and Sustainer, unto Thee belong all praises and all sovereignty. We seek Thy aid and Thy guidance in the assembly which we have gathered to hold. Bestow upon us health of body, serenity of mind, and strength of spirit, that we may partake in this gathering with thankful and reverent hearts. Grant us, we beseech Thee, Thy divine favor, that this, our event, may proceed without hindrance or difficulty. We place our trust in Thee alone, acknowledging that our success is not but through Thy power and Thy leave. Bless Thou our endeavors and the purpose of our gathering, and grant that it may bring forth beneficial fruit for us and for the community. Forgive us our transgressions and shortcomings, and accept our supplications, for Thou art the great forgiver and the most merciful. Ya Latif, Ya Rahman, O subtle one, O most merciful one, the righteous judge of all the earth, we give Thee humble thanks for that Thou hast safely brought us to the commencement of this new legal year. Upon this blessed morrow, at the commencement of the Sabah and Sarawak opening of the legal year 2026, we, Thy humble servants, do beseech Thee, O Allah, to grant us Thy manifold blessing. Vouchsafe, we pray Thee, to inspire all who minister justice in this realm, from the highest judge unto the humblest officer, with the spirit of wisdom, uprightness, and true discernment. Grant that they may ever be mindful of their high calling, that they may execute judgment with mercy and without partiality, so that peace and the rule of law may flourish within this land of Sabah and Sarawak and throughout all our nation. Defend us in all our doings with Thy mighty power, that all our counsels may tend to Thy honor and glory. Endue us with all heavenly gifts and prosper our righteous undertakings. Hear our supplications, we beseech Thee, and grant us Thy grace, that we may serve Thee with a quiet mind, to the good of Thy people and to the glory of Thy holy name. ربنا آتنا في الدنيا حسنة وفي الآخرة حسنة وقنا عذاب النار وصلى الله على سيدنا محمد وآله وصحبه وسلم والحمد لله رب العالمين. May Allah receive with favor both that which we have offered and that which ye have offered. Taqabbalallahu minna wa minkum.
Minna wa minkum taqabbal ya karim. Thank you, Tuan Hurman Hussein.
Hear ye, hear ye. Let all who have business before His Lordship, the Right Honorable Chief Justice, Datuk Sri Utama Wan Ahmad Farid bin Wan Saleh, their Lordships and their Ladyships, draw near and give your attendance. My ladies and my lords, this is in the matter of the Sabah and Sarawak opening of the legal year 2026, holden at Kota Kinabalu, Sabah.
I will now invite the Honorable Datuk Muhammad Nazim bin Madwaran, President of Sabah Law Society, to deliver his speech.
Bismillahirrahmanirrahim. May it please your lordships, the Right Honorable Chief Judge of Malaysia, the Right Honorable the President of the Court of Appeal of Malaysia, the Right Honorable Chief Judge of Sabah and Sarawak, the Right Honorable Chief Judge of Malaya, the Right Honorable Attorney General of Malaysia, the Honorable Deputy Minister in the Prime Minister's Department, Law and Institutional Reforms, Honorable Judges of the Superior Courts and Judicial Commissioners, the Honorable State Attorney General of Sabah, the Honorable State Attorney General of Sarawak, the Honorable President of the Advocates Association of Sarawak, the Honorable President of the Malaysian Bar, distinguished guests, ladies and gentlemen. There's an old song that asks whether we have ever seen rain falling down on a sunny day. I believe this morning's procession reminds us that such moments exist and that our profession is defined by how we respond when they do. And for us members of the Sabah and Sarawak Bar, it's clear, rain or shine, we stay calm and carry on. My lords, what matters most in the opening of the legal year is not the parade, especially not today's rainy parade, but the reflection and accountability that follow. Ritual has its place, but ritual without reflection becomes a habit, and habit without accountability becomes inertia. The opening of the legal year is not performance. It is a moment for the legal profession to pause, to assess what has endured, what has failed, and what must now change. Meaningful work is rarely easy, but what endures is not what is inherited unquestioned or followed blindly. What endures is what proves useful, disciplined, and fit for purpose. That is the spirit in which the Sabah Law Society approaches this legal year, not theoretically, not dramatically, but institutionally. Sabah's participation in professional and institutional structures reflects cooperation, not consolidation. We engage as equals because we are equals. The Sabah Law Society is a statutory body established by federal statute. It's not a regional appendage defined by perception. Our contributions to the legal profession in this country is not aspirational, it is established, and respect follows fact, not permission. Recent amendments to the Legal Profession Act, which includes reforms recognizing Sabah and Sarawak representation on the Legal Profession Qualifying Board, did not create this reality. It acknowledged belatedly an institutional truth that had long existed, even when it was not openly recognized. Brotherhood, as Malcolm X reminded us, is a principle and not a plea. It is extended in good faith without surrender of dignity. This has always defined the Sabah Law Society's engagement with the Malaysian Bar, the Advocates Association of Sarawak, and the International Legal Fraternity. Our standing is also reflected externally, as in 2027, Sabah Law Society will host the ASEAN Bar Leaders Summit, not as a courtesy venue, but as a regional legal actor trusted to convene, contribute, and lead. When cooperation no longer suffices, what anchors all the work that is still standing? The answer is not in personality, but in constitutional memory. In October 2025, a decision of the High Court in Sabah did more than resolve a legal question. That decision reaffirmed a foundational principle of our constitutional order, that the courts in this country are independent and that they are guided by law. The issues before the courts were determined on legal principle, not political convenience, and without regard to sentiment or pressure. This constitutional litigation concerning Sabah's rights under the federal constitution, including provisions relating to financial arrangements and federal state obligations, has reminded us of a basic truth. When constitutional duties are neglected for decades, the courts retain both the authority and responsibility to give effect to the Constitution, because the Constitution is not optional. As Malcolm X again reminded, history is a people's memory, and rights that are not remembered become rights that are not respected. Rights that are not respected in time are treated as they never existed. The Sabah Law Society takes the position that constitutional arrangements are not historical footnotes. They are living obligations that continue to shape governance, accountability, and justice in this federation. Accordingly, the SLS will continue to advance, defend, and explain what is due to Sabah under the federal constitution, not as a matter of politics, but as a matter of law. We will take a more proactive role in educating Sabahans about the constitutional arrangements that shape this federation, because these are not abstract provisions. They are part of Sabah's legal history and part of its present legal reality. This work is carried out through our law reform committees, research initiatives, and constitutional advocacy task force, not as a commentary, but as an institutional duty. Many speeches and reports have spoken on the urgent need to revise outdated laws, including Land Subsidy Title Enactment 1972 and the Town and Country Planning Ordinance. Yet, year after year, the refrain remains the same, studied by one committee, reviewed by another. There's no such thing as a perfect law, but delay in the name of perfection carries its own cost. Law reform is not measured solely by what we announce. It is measured by what we activate, including implementation that allows citizens meaningful access to quasi-judicial functions, and above all, fair and just treatment throughout the process. However, there are low-flying routes ripe for immediate implementation. One such route is the appeal board under Section 28L of the Town and Country Planning Ordinance, statutorily constituted decades ago and awaiting only appointment. In a state experiencing sustained land development, institutional checks and balances are not optional. Another is the designation of digitally ready departments or written laws under Section 6 of the Electronic Government Activities Enactment 2014, enabling lawful electronic transactions, recognized electronic signatures, and accessible digital processes. Lawyers have adapted. Courts have adapted. It's time the wider system followed. And when reform is delayed or left incomplete, the cost is not abstract. It is carried by the people. Sabah has not waited for federal law to set the pace. In July 2025, the State Legislative Assembly passed the Climate Change and Carbon Governance Enactment 2025, affirming that carbon rights within the state belong to Sabah. The law establishes the Sabah Climate Action Council, a state-level climate registry and fund, and embeds safeguards to ensure indigenous consultation and community benefit sharing. These are examples of law reform not merely discussed in principle, but written, enacted, and waiting determined implementation. At the same time, Sabah is entering a demographic phase where a single cohort carries overlapping responsibility, economic, familial, and legal. Most of this single cohort were born in the 20th century, as do most of us in this room today. At the same time, many continue working, expanding sideways rather than upwards, sustaining aging parents, managing succession, absorbing care responsibilities while remaining economically active themselves. As a result, this same cohort becomes the financial, legal, and emotional engine of the silver economy. The Labor Ordinance of Sabah Amendment Act 2025 may not use the term silver economy, but it squarely serves its purpose by enabling flexible working arrangements, extended statutory protection to all employees regardless of salary, and recognizing that medical interruptions should not end working lives. The law acknowledges a simple reality. Many Sabahans work longer, not by choice, but by necessity. Labor law reform in this sense is not adjacent to the silver economy. It is foundational to it. And when so much responsibility converges at once, economic, familial, legal, the integrity of the profession is no longer abstract. It becomes the line that holds everything together. When the law meets people at their most vulnerable, the measure of justice is no longer theory or professional policy. It's professional conduct. Professional integrity, it's not static. It evolves with the demands placed upon it. While professional publicity rules have been updated under the Legal Profession Act for Peninsular Malaysia, Sabah's position remains clear. The Sabah Law Society regulates its members under the Advocates Ordinance. In that capacity, we are reviewing our own rules to ensure that professional conduct, dignity, and public trust remain aligned with contemporary realities. Strong professions do not wait to be told on how to govern themselves. My lords, I end with a reminder that I always return to. Let every soul consider what it has sent on for tomorrow. Surah Al-Hashr 18, chapter 59, verse 18. For institutions, tomorrow is not rhetoric. It is structure. It's memory. It is continuity. The Sabah Law Society will continue to stand, not loudly, not deliberately, not theatrically, but institutionally. We extend the same faith to our courts, that the courts continue to stand above turbulence, guided by law, not by sentiment or convenience. Because institutions that matter do not applause, do not chase applause. They build systems and they are remembered. Happy New Year, my lords, and happy opening of the legal year, Sabah and Sarawak 2026. Much obliged.
Thank you, Datuk Muhammad Nazim. I will now invite the Honorable Mr. Gurveer Singh Sandhu, President of the Advocate Association of Sarawak, to deliver his speech.
A very good morning, the Right Honourable Chief Justice of Malaysia, the Right Honourable President of the Court of Appeal, the Right Honourable Chief Judge of Sabah and Sarawak, the Right Honourable Chief Judge of Malaya, the Honourable Attorney General of Malaysia, the Honourable Deputy Minister in the Prime Minister's Department, Law and Institutional Reforms, the Honourable Judges of the Superior Courts and Judicial Commissioners, the Honourable State Attorney General of Sabah, the Honourable State Attorney General of Sarawak, my learned friend, the Honourable President of the Sabah Law Society, my learned friend, the Honourable President of the Malaysian Bar, judicial officers, fellow learned friends, distinguished guests, ladies and gentlemen. The opening of the legal year is not merely a ceremonial rite. It is a public recommitment by the judiciary and the legal profession to the rule of law, to judicial independence, and to the public confidence on which our institutions ultimately depend. It is a time when we pause, reflect, to renew our promise to uphold these foundations of justice. This occasion also carries a spiritual resonance deeply rooted in our region's legal traditions. The proceedings this morning started off firstly with a dua. In Sarawak, the annual Red Mass at St. Thomas's Cathedral gathers judges, advocates, and judicial officers in prayer for wisdom, humility, and fairness. Likewise, diverse communities mark the legal year in their own way, including the SICC Legal Year 2026, which will be observed at the end of this month through a Sahaj Path at the Gurdwara Sahib Petaling Jaya. These traditions remind us that the practice of law is not only technical or procedural, but also moral, reflective, and grounded in conscience. For Sarawak, this occasion carries particular weight. We practice law across vast geography in a tapestry of diverse cultures and under constitutional arrangements that are uniquely our own. Our courts are often the most visible and sometimes the only face of justice for many remote communities. That reality must shape how we think about judicial independence, about appointments, and about reforms. My lords and my ladies, the Judicial Appointments Commission was created to professionalize and depersonalize judicial appointments. That objective remains sound, but experience has shown that further refinement is required if confidence is to be strengthened. From the perspective of Sarawak, I respectfully highlight several areas of legislative reforms which is urgently needed. First, the composition of the JSC must be broadened. It is glaring that the most significant stakeholders, the advocates, are not represented as members. To ensure meaningful balance, regional representation, and institutional diversity, we must advance the position that each bar from the 3 separate jurisdictions, namely the Malaysian Bar, the Sabah Law Society, and the Advocates Association of Sarawak, must be appointed as full voting members of the JSC. Second, the JSC must reflect the whole federation, with guaranteed representation from Sabah and Sarawak, and with appointments that uphold gender, racial, and geographic diversity. This would be a reflection of the true fabric of Malaysia. Thirdly, the transparency of process must be enhanced. Clear statutory criteria on merit, integrity, experience, temperament, and independence should be expressly codified. Fourthly, the current breadth of executive discretion must be recalibrated. My lords and my ladies, these are not radical changes. These are structural safeguards designed to fortify public trust in the judiciary. My lords and my ladies, recent public commentary has questioned certain appointments to the JSC on the basis that, among others, members were said to be too new at a particular level of court. Allow me to address this directly. To challenge an appointment solely on the basis of short tenure at a specific judicial tier is to misunderstand judicial merit and risk unintended constitutional consequences. Judicial excellence is not measured by the number of years spent at one rung of the judicial ladder. It is measured by, among others, integrity, independence of mind, clarity and quality of one's judgments, by temperament, and by an unwavering commitment to justice. To insist that only the longest serving judges are fit for elevation is to reduce merit to a chronological tally. In fact, if this logic were to apply strictly, it would constitute a collateral attack on the legitimacy of our recent senior judicial appointments made precisely because ability and leadership were recognized above length of service. In late July 2025, Malaysia saw a significant change in the Judicial Guard, where we welcome a new Chief Justice, a new President of the Court of Appeal, a new Chief Judge of Sabah and Sarawak, and more recently, a new Chief Judge of Malaya. These appointments were notable because they identified and placed capable individuals in key positions at the right time. Therefore, my lords and my ladies, we take a firm but respectful position. Youth, recent elevation, or shorter tenure should never be disqualification for higher or judicial office. A judiciary that truly values merit must recognize talent early and avoid ossifying the system through informal conventions not found in the Constitution. That is not to say that experience counts for nothing, but experience takes many forms, and brilliant jurists should not be held back simply because of time served. My lords and my ladies, we are encouraged by the calls for institutional strengthening aligned with major reforms which is now advanced by the federal government. This year, we are pleased to note that the government has embarked on 3 landmark reforms for 2026, which are separation of the Attorney General and the Public Prosecutor's Office, establishment of the Ombudsman Malaysia, and the Freedom of Information Bill. These reforms collectively represent one of the most ambitious efforts to modernize Malaysia's governance landscape in recent decades, aligned with transparency, accountability, and the rule of law. Their momentum should be acknowledged and supported by stakeholders all around. My lords and my ladies, the Malaysia Agreement 1963 remains central to Sarawak's constitutional identity. Sarawak continues to make structured, consistent, and legally grounded progress through a dedicated Minister of Law for MA 63 and a capable State Attorney General chambers. This has enabled informed negotiations and principled engagements with the federal government. These institutional strengths have enabled Sarawak to assert its right confidently without resorting to confrontation. Recent years have seen earnest, solution-oriented discussions between the state and federal governments, reflected in the MA 63 implementation committees, amendments to federal laws, and continuing engagement on matters such as financial grants, devolution of powers, and greater autonomy in key sectors. This approach demonstrates that Sarawak is fully capable to protect its rights within the constitutional architecture of the Federation. Sabah and Sarawak may have taken different approaches shaped by their unique realities. What matters is the shared constitutional foundation, the Malaysia Agreement, and the subsequent constitutional amendments that gave it legal effect. From the standpoint of the legal profession, one principle must remain clear. Compliance with MA 63 should be automatic, principled, and proactive, not contingent on litigation. But this does not mean that Sarawak will sit idle in the event mutual discussions do not bear fruit. The federal government should honor its constitutional commitments administratively and legislatively, and this will in turn reinforce the public's confidence in federal-state relations, and the spirit of MA 63 is upheld both in letter and in substance. My lords and my ladies, allow me to now turn to a practical concern that is ever present in Sarawak: access to justice across a state almost as large as the entire peninsula of Malaysia. Circuit sittings remain one of the most effective ways to bridge distance. We appreciate the Chief Justice's continued commitment to this initiative, including the return of the Court of Appeal to circuit in Miri this year. This brings justice closer to communities, especially in native customary rights matters where it is not uncommon for entire villages to attend court to witness the hearings, and this also provides an invaluable exposure for young practitioners. But physical presence alone cannot meet Sarawak's needs. Given our vast geography, technology must serve as an equal pillar. Continued support for remote attendance, particularly for mentions and interlocutory matters before the Court of Appeal, will save enormous time and cost for litigants. With consistent refinement of our digital court system, we can effectively bring the courts virtually into every corner of the state. Access to justice also extends beyond the courtroom. We welcome the judiciary's commitment to strengthening mediation and ADR. In light of increasing caseloads, it is timely to adopt systematic approaches. And I'm pleased to note that the Rules Committee had unanimously approved proposals to introduce mandatory mediation for civil cases before trials. We look forward to its implementation in the rules of court. My lords and my ladies, I must now speak on a matter affecting the long-term sustainability of our profession, the well-being of lawyers. Across many jurisdictions, studies show rising attrition among lawyers and young advocates, with heavy workloads, tight timelines, and the pressures of practice contributing to burnout and early departures from the profession. This is not merely an international phenomenon. The pressures and the realities of court practice are equally felt by lawyers and prosecutors in Sarawak. We have all heard of colleagues who left the bar only after a few years, or have moved away from court litigation practice, or prosecutors who have asked for transfer to less demanding roles. The Chief Justice himself, in his Lordship address at the opening of the legal year, emphasized the well-being of judges and the urgent need for more judges to handle soaring caseloads. His Lordship also used a vivid analogy in his address, likening the judiciary to a kitchen where the heat of the fire tests those who serve within it. I can assure you, Yang Mat Arif, if there is heat in the kitchen, lawyers are feeling it too. That message resonates deeply because stress within the justice system does not exist in isolation. More cases mean more pressure on judges, prosecutors, and lawyers alike, and that pressure ultimately affects fairness, quality, and the humanity of justice delivery. My lords and my ladies, while I am on this subject, it would be remiss of me not to mention a concern which has direct correlation to the heat the lawyers are feeling, and that is the impact of judicial temperament in court. We fully appreciate that judges themselves are under tremendous strain from growing caseloads and increasing demand on their time. However, when court becomes overly tense, when exchanges become curt, or when timelines become compressed beyond what counsel can reasonably manage, the stress felt by judges inevitably flows downstream to lawyers, prosecutors, and even court staff. We raise this matter not in criticism, but in recognition that courtroom tone is an integral part of the administration of justice, and that a calm, patient, and measured environment helps all of us to perform our duties with dignity and effectiveness, even amidst mounting pressures. To this end, we express readiness to work with the judiciary to establish a guideline to study workloads, scheduling practices, training needs, and systematic measures that support a sustainable profession. In closing, my lords and my ladies, the matters we have raised today are not abstract concerns. Our courts deal with a variety of cases daily. The stakes are high, the pressures are real, and the work of the courts and the legal profession has direct impact on the lives of our people. In the justice delivery system, we must remember that the law, at its heart, is a human endeavor. It must have a human face and a humane touch, even as it remains firm and principled. On a personal note, during a spirited debate, I was once reminded by a magistrate that I will not be president forever. That comment stayed with me. It reminded me of a simple truth. All of us, from the bar to the bench and even the top four, occupy our seats only for a moment in time. These offices are held in trust, not in perpetuity. Our responsibility is to leave them stronger than we found them, with institutions more resilient, more transparent, and more accessible for those who come after us. As we open the legal year 2026, let us step forward with clarity of purpose and a shared commitment to ensure that justice prevails in every corner of Malaysia. With that, my lords and my ladies, may the year ahead be one of fulfillment, integrity, and justice for all. I am very much obliged. Thank you.
Thank you, Mr. Gurveer Singh. I will now invite the Honorable Dato' Brandon Keith So, State Attorney General, Sabah, to deliver his speech.
The Right Honourable Chief Justice of Malaysia, the Right Honourable President of the Court of Appeal of Malaysia, the Right Honourable Chief Judge of Sabah and Sarawak, the Right Honourable Chief Judge of Malaya, the Honourable Attorney General of Malaysia, the Honourable Deputy Minister in the Prime Minister's Department, Law and Institutional Reforms, Honourable Judges of the Superior Courts and Judicial Commissioners, the Honourable State Attorney General of Sarawak, the Honourable President of the Sabah Law Society and Presidents of the Advocates Association of Sarawak, the Honourable President of the Malaysian Bar, distinguished guests, ladies and gentlemen. On behalf of the State Attorney General Chambers of Sabah, I extend our respectful salutations and the warmest of greetings to everyone present for this joint opening of the legal year 2026 for Sabah and Sarawak, here in Kota Kinabalu, the state capital of the land below the wind. This time-honored event gathers together every part of our legal fraternity and invites us to pause and consider the hurdles and milestones of 2025 while setting our shared priorities and recommitting ourselves to our true north, the fair, impartial, and fearless administration of justice. At the outset, here in our home state, it is a distinct privilege for me to extend our profound welcome and congratulations to Yang Amat Arif, Datuk Seri Utama Wan Amit Farid bin Wan Saleh, on your appointment as our 17th Chief Justice of Malaysia last year. We salute your role as the new custodian of justice, whose leadership will shape our jurisprudence, guide our institutions, and inspire the legal community in service to the people and the Constitution. Yang Amat Arif's maiden opening of the legal year speech earlier this week left a strong impression for direction with reference to the 10-year judicial blueprint and your resolve to strengthen capacity so that justice is delivered both swiftly and fairly. We stand ready to assist you in all your efforts to fortify the judiciary. We would also like to acknowledge and commend the appointments of Yang Amat Arif Dato' Abu Bakar bin Jais, President of the Court of Appeal, Yang Amat Arif Dato' Hashim bin Hamzah, the Chief Judge of the High Court of Malaya, and Yang Amat Arif Dato' Haja Aziza bin Haji Nawawi, the Chief Judge of the High Court in Sabah and Sarawak. We are certain that you will all further enrich the collective wisdom of the bench and support the continuing partnering of the judiciary, the bar, and chambers in upholding justice. When drafting this speech for this significant annual occasion, I'm always reminded about the importance of making reference to that universal principle, the rule of law. More so now, given the grave concerns globally of the recent developments in Venezuela and Greenland, where due process, sovereignty, and respect for international legal principles are being severely tested. This unfortunate moment in our world order ought not to distract, but serve as a necessary motivation to reaffirm and reassert our commitment to the rule of law as the bedrock of constitutional order, ensuring that the rights of all are protected, institutions are respected, and justice is never subordinated to expedience. Lord Bingham once described the rule of law as one of the greatest unifying factors, perhaps the greatest, and an ideal worth striving for, in the interests of good government and peace at home and in the world at large, unquote. Those words ring so true today as they always have been. Whilst on the subject of law and closer to home, I would like to share some of our statutory achievements for 2025, often an onerous task for our drafters to ensure that the policy set by the executive is clearly reflected in the substance and words of legislation, whilst accommodating the views of all stakeholders. Most of all, it needs to stand up to the scrutiny by our legislators, and this can be a cause of either unanimous support or, more often than not, serious debate. Sabah witnessed 7 enactments being tabled last year. Among them was a much-needed incorporation of the indefeasibility of title concept in our land ordinance, with the insertion of Section 88A, thus bringing our state law in line with both the Sarawak Land Code and the National Land Code. This provides certainty and confidence for subsequent bona fide purchases without notice, without which the apex judicial interpretation had determined that Sabah's modified torrent system of land registration did not protect the good title of an infinite number of subsequent innocent purchasers. The conveyancing practitioners were the first to laud this achievement, and I also extend my gratitude to the Sabah Law Reform Advisory Council, led by Tan Sri David Wong, the former Chief Judge of Sabah and Sarawak, for this initiative. Sabah also pioneered Malaysia's first agricultural fertilizer law. This enactment seeks to control the manufacture, import, export, and sale of fertilizers to ensure safety and quality. It will tackle key challenges such as the prevalence of substandard fertilizers, advancing sustainable farming practices, and protecting consumers, thus ensuring food security and enhancing environmentally responsible practices. From a revenue perspective, the state sales tax enactment of 1998 underwent a comprehensive overhaul last year, paving the way for a more transparent, fair, and efficient tax system. Key outcomes include the refining of the definition of a sale to include the movement of taxable goods out of Sabah, as well as anti-avoidance provisions to uphold the integrity of business dealings and protect the state income from deliberate leakages. With almost half of our state budget being derived from sales tax, these amendments were a crucial strategic reform. Now, my learned friend, Datuk Nazim, had already mentioned the Sabah Climate Change and Carbon Governance Enactment, and I'll just add that it will also regulate the emission of greenhouse gases from industries in the state. We in Sabah, as a natural net carbon sink, where we absorb more carbon than we emit, are already ahead of the global expectations set under the Paris Agreement. Thus, it is crucial to acknowledge our role towards contributing to the national climate targets, whilst at the same time establishing a framework that builds institutional climate resilience at the state level. Now, before leaving the accomplishments of 2025, it would be remiss of me to not acknowledge a moment of historical significance and relief last month, namely the annulment in full by the Paris Court of Appeal of the purported final award against Malaysia in favor of the alleged heirs of the now defunct Sulu Sultanate, involving the rogue arbitrator Gonzalo Stampa. This decision confirms the consistent position that there was no jurisdiction to make that award, as there was no valid arbitration agreement binding the nation. We wish to record the sterling efforts of the federal government, led by the Minister in the Prime Minister's Department of Law and Institutional Reform, together with the Federal Attorney General Chambers and all other agencies, for their commitment and success in defending this baseless claim centered on Sabah. The ruling ends the misuse of arbitration for a deceptive commercial claim, and I hope this decision will permanently put to rest any uncertainty over the sovereignty of our state and federation. Now, turning to my attention to the path ahead, we anticipate significant milestones for 2026, continuing the significant progress that we have made in the implementation of the Malaysian Agreement 1963 within the spirit of our federation. We will witness a federal extension of legislative power to Sabah to pass laws for scheduled wastes by activating Article 95C of the Federal Constitution. This will correspondingly enable the state to amend its Environmental Protection Enactment, providing for the regulation of hazardous materials within its borders, thus enhancing environmental authority and governance at the local level. We would also like to record our appreciation for the announcement by the Deputy Prime Minister of Malaysia, Datuk Sri Fadillah Yusof, the Chairman of the MA63 Technical Committee, in relation to the role of the Yang di-Pertuan Negeri in Sabah and Sarawak in certifying the names of eligible candidates to be appointed as judicial commissioners by the Yang di-Pertuan Agong. Whilst this process is currently being undertaken administratively, it has been agreed that amendments to the Judicial Appointments Commission Act and the Federal Constitution are necessary so as to enshrine this return of authority to the state. Continuing in a similar vein, we also look forward to constructive and solution-orientated engagements with the Federal Attorney General Chambers regarding the state's intended regulatory role on tourism, which was originally a residual legislative power under Article 77 of the Federal Constitution, before being placed in the federal list by a constitutional amendment in 1994. Returning tourism to state supervision, as was originally envisaged at the formation of Malaysia, is vital, as it will enable the design and drive of policies tailored to the unique community-based geography and economic potential of Sabah. One final note I would like to make is the welcome announcement in September last year that there is in principle support for the increase of parliamentary seats for both Sabah and Sarawak as a step towards restoring the more than one-third parliamentary representation and safeguard for the Borneo states. the declassification of the Albatross file by Singapore, whilst potentially sensitive, ought to be viewed with a constructive lens in helping us understand history and the swift chronology in how those 15 seats that Singapore originally had were not eventually redistributed to Sabah and Sarawak. We look forward with renewed optimism and tangible outcomes will be achieved in the coming year to restore the original constitutional design of our federation, which will only further strengthen the fabric of our nation. Internally, as an organization, I feel it is important to say a few words on our commitment to training, development, and growth. Last year, we arranged for 3 interactive seminars on key matters such as legislative drafting, enforcement, and the preparation of investigation papers for the prosecution of state offenses. This year, we aim to more than double this to 8 targeted capacity building seminars for our legal officers, working with established institutions like the Academy Perundangan Negara, as we have often done in the past. There can be no substitute for continued learning. As we discuss the future, there is another prominent issue that has arisen in many legal jurisdictions, including our own, that of artificial intelligence and the wider implications for our fraternity. Now, the legal sector is not insulated from how AI can transform legal work. We can expect that it will not be gradual or optional, but swift and structural. Already, impacts are being felt with AI-supported contract analysis, due diligence, and legal research. We're all too familiar that our current offices, lined with those law reports, have become more art than resource, admired, respected, and almost entirely unread. And this is just the start, with AI also playing a role in strategic contexts, such as negotiations, planning, and decision-making. It can also potentially assist in closing that justice gap by making access to justice affordable for the unrepresented. However, fundamental questions ought to be asked as to who can own legal data. How is it governed? Is AI trained on past legal work? How does it avoid reinforcing obsolete prejudices or misconceptions? Will we, as a nation, need to consider an AI legislation to regulate and promote ethical, safe, and human-centric AI development? Fortunately, there are some things that AI can't do yet, such as exercise human craft and judgment, understand the context of unwritten norms or local sensitivities, and represent clients ethically and compassionately with both reason and experience. Furthermore, trial room advocacy skills cannot be replicated. So for now, I'm personally relieved that we will all continue to be employed, but we must not ignore an AI-powered future. At this juncture, I would like to also take this opportunity to congratulate Yang Arif Mas Linda binti Muhammad Ainal, Yang Arif Dato' Fariz Goldam bin Abdullah, and Yang Arif Saiful Azian bin Mokhtar for their elevation as High Court judges. Both Yang Arif Leonard Shim and Yang Arif Dato' Dr. Lim Hock Leng for their elevation to the Court of Appeal, and to Yang Arif Hamid bin Ismail, Yang Arif Steve Ritkos, and Yang Arif Ratana Devi binti Yusof Perumal for their appointment as Judicial Commissioners. I wish you the very best in your noble roles. Given the recurring theme of rivers earlier this week, at the opening of the legal year in Kuala Lumpur, allow me to close with a pantun in Dusun Kujau. Bawang kinabatangan lumuyong mayampai it kampong, o sundu do aros moguit harapan, undang-undang o tungkus do piombuus, keadilan om katantu dari janji toko. Translated, it means, the Kinabatangan River flows through village lands. Its currents unite, carrying hope. The law stands firm through all time. Justice and truth, our pledged duty. With that, and on behalf of the State Attorney General Chambers of Sabah, I pledge the fullest support to the judiciary in the discharge of your constitutional responsibility to administer justice. Finally, we are also greater than the sum of our parts, and this is also an opportune time for me to express my gratitude to my deputies, Datuk Dayangku Fazira Hatun Pengiran Bagul and Puan Suzumaida Haji Hussein, and all the legal officers and staff of the State Attorney General Chambers for their collective efforts last year. May we springboard onwards and upwards this year. My sincere wishes to everyone for a meaningful and successful 2026. May we advance our shared endeavors in the principled and diligent fulfillment of our legal responsibilities and public duties. Much obliged.
Thank you, Dato' Brandon. I will now invite the Honorable Dato' Sri Safri bin Ali, State Attorney General of Sarawak, to deliver his speech.
The Right Honourable the Chief Justice of Malaysia, the Right Honourable the President of the Court of Appeal of Malaysia, the Right Honourable the Chief Judge of Malaya, the Right Honourable the Chief Judge of Sabah and Sarawak, the Honourable Attorney General of Malaysia, the Honourable Deputy Minister in the Prime Minister Department, Law and Institutional Reforms, Honourable Judges of the Superior Courts and Judicial Commissioners, the Honourable State Attorney General of Sabah, the Honourable Presidents of the Sabah Law Society, the Honourable Presidents of the Advocate Association of Sarawak, the Honourable Presidents of the Malaysian Bar, distinguished guests, ladies and gentlemen. Assalamualaikum warahmatullahi wabarakatuh. Salam sejahtera, salam Sarawakku sayang, salam Sarawak maju makmur, dan salam segulai sejalai. Alhamdulillah, syukur kehadirat Allah Subhanahu wa Ta'ala, kerana dengan izin dan rahmatnya kita dapat bersama-sama pada pagi ini bersempena dengan pembukaan Tahun Perundangan Sabah dan Sarawak 2026. My lords, my lady, may I begin by expressing my deepest appreciation to the Malaysian judiciary, in particular to the Right Honourable Chief Justice of Malaysia, for the privilege and honor of addressing this distinguished gathering of the legal fraternity on this auspicious occasion of the opening of the legal year 2026. On behalf of my colleagues in the State Attorney General Chambers, I wish to take this opportunity to congratulate Yang Amat Arif, Datuk Sri Utama Wan Ahmad Farid bin Wan Saleh on your Lordship's appointment as the Chief Justice of Malaysia, Yang Amat Arif, Datuk Abu Bakar bin Jais on your Lordship appointment as the President of the Court of Appeal, Yang Amat Arif, Datuk Hajah Azizah bin Haji Nawawi on your Ladyship's appointment as the Chief Judge of Sabah and Sarawak, and Yang Amat Arif, Datuk Hashim bin Hamzah on your Lordship appointment as the Chief Judge of Malaya. Your Lordship and Ladyship's appointments clearly reflects the nation's confidence in your integrity and experience in the administration of justice. We are confident that the judiciary will continue to discharge its constitutional role and with distinction and independence. I also wish to warmly congratulate the judiciary on the initiatives undertaken under the Judicial Blueprint, a decade of purposeful reform, as announced by the Chief Justice during the opening of the legal year in Kuala Lumpur last Monday. One such initiative is the launch of the Court of Appeal Circuit Initiative, whereby the appellate sittings will be held outside Putrajaya, including a sitting scheduled in Miri this year. This will address the limited exposure and access previously faced the practitioners outside the Klang Valley. This demonstrates that Malaysia's judicial system has taken a significant step toward expanding public access to justice. This is a timely move which would strengthen the administration of justice in Sarawak. My lords, my lady, in 2025, the Sarawak State Legislative Assembly enacted several significant laws reflecting the state's commitment to sustainable development, good governance, and institutional reform. There are, among others, as follows: the Land Code Amendment Ordinance 2025, Sarawak Biodiversity Centre Amendment Ordinance 2025, the Constitution of State of Sarawak Amendment Ordinance 2025, Building Amendment Ordinance 2025, and Sustainable Resources and Waste Management Ordinance 2025. As often emphasized by the Right Honorable Premier of Sarawak, waste is not wasteful, but useful. Don't waste the waste, monetize the waste. In the past, waste has been seen as a nuisance to be buried and burned. The introduction of the Sustainable Resources and Waste Management Ordinance establishes a single centralized authority to regulate sustainable resources and waste management, providing the legal foundation for a circular economy model that aligns environmental protection with economic value creation and long-term sustainability. In parallel, the amendments to the Building Ordinance 1994 modernized Sarawak construction regulatory framework through the introduction of green building standards, updated compliance mechanism, and sustainability requirements, marking Malaysia's first statutory framework regulating green buildings and certification. Together, the drafting of these two landmark legislation reflect the Chamber's proactive and strategic role in supporting Sarawak's transition towards a green economy. It demonstrates our commitment to translating policy vision into enforceable legal frameworks that advance Sarawak sustainable development, align with Sarawak environmental and climate policies, and position Sarawak as the national leader in green legislation and governance. My lords, my lady, Malaysia Agreement 1963. The mission of our chamber is to provide a responsive, reliable, and efficient public legal service through close collaboration with stakeholders grounded in good governance, professionalism, and ethical conduct. In this regard, meaningful progress has been achieved in advancing Sarawak rights and safeguards under the MA 63, including the amendments to the Sarawak Labour Ordinance, which came into force on the 1st May of 2025, restoring regulatory autonomy over labour matters, and the reclassification of Bintulu Port as the state port, strengthening Sarawak's role in its economic governance. At the same time, Sarawak continues to pursue, through lawful and constitutional process, the restoration of the constitutional balance originally envisaged at the formation of Malaysia, including the aspiration of one-third representation in Parliament for Sabah and Sarawak collectively. Historically, this arrangement functioned as an institutional safeguard to ensure meaningful participation by the Borneo states in national lawmaking and constitutional change. Sarawak efforts in this regard are pursued through structured engagement, consensus building, and full adherence to the Federal Constitution, MA 63, and the IGC reports. Nevertheless, certain matters remain outstanding, including an order to be made under Article 95C of the Federal Constitution to empower Sarawak government to manage scheduled waste. These chambers respectfully urge the expeditious implementation of the necessary constitutional instrument to allow Sarawak to have full control over environmental matters, since it has been agreed by parties. My lords, my lady, the Sarawak government welcomes the High Court decision in affirming Sabah entitlement to its 40% revenue share under Article 112C of the Federal Constitution. While the ruling applies directly to Sabah, it affirms the constitutional duty of the federal government to honor its financial obligation to both states, subject to judicial scrutiny. Under Article 112D, Sarawak remains entitled to a periodic financial reviews and the negotiation on a fair and transparent manner. In this regard, Sarawak has submitted a formula to the federal government to facilitate and expedite the review process. Pending the finalization of this formula, the interim special grant has been increased to RM 600 million annually from 2025. Sarawak will continue to engage constructively and in good faith with the expectation that the necessary process at the federal level will be concluded in a timely manner to enable a durable long-term settlement. As those entrusted with providing legal advice, we must approach these matters with a broad and balanced perspective. This necessarily requires consideration not only to the strict letter of the law, but also of the historical context and the original intention underpinning the decision made at the time of the formation of Malaysia. Malaysian, which includes Sarawakian and Sabahan, have placed their trust in us to deliver not merely sound legal advice, but principled and practical solutions that advance fairness, strengthen the federation, and achieve outcomes of mutual benefit without denying or diminishing the rights of any party. My lords, my lady, in October 2025, our chambers had convened the second International Legal Talk series focusing on constitutional safeguard within Malaysia's federal structure. Such initiatives promote legal literacy, informed discourse, and a deeper appreciation to the constitutional foundation underpinning Sarawak's position within the Federation. The chambers look forward to holding more of these talks and in fact would like to include all parties to participate to foster a closer working relationship. To conclude, as we enter 2026, the legal fraternity remains bound by a shared duty to uphold the rule of law with integrity, independence, and fidelity to constitutional principles. These chambers remain steadfast in advancing Sarawak within the Federation, guided by the fundamental commitment that constitutional promises must be honored and justice faithfully served. With that, much obliged.
Thank you, Datuk Sri Safri. I will now invite the Honorable Tan Sri Muhammad Dusuki bin Mokhtar, Attorney General of Malaysia, to deliver his speech.
If I may, my lady, my lord, the Right Honourable Chief Justice of Malaysia, the Right Honourable the President of the Court of Appeal of Malaysia, the Right Honourable the Chief Judge of Sabah and Sarawak, the Right Honourable the Chief Judge of Malaya, the Honourable Deputy Minister in the Prime Minister's Department, Law and Institutional Reforms, Honourable Judges of the Supreme Courts and Judicial Commissioners, the Honourable State Attorney of Sabah, the Honourable State Attorney General of Sarawak, the Honourable President of the Sabah Law Society, the Honourable President of the Advocates Association of Sarawak, the Honourable President of the Malaysian Bar, distinguished guests, ladies and gentlemen, Assalamualaikum warahmatullahi ta'ala wabarakatuh. A very good morning, warm greeting, salam Malaysia Madani, salam Sabah Maju Jaya, and salam Sarawak Segulai Sejalai. Yang Arif, ladies and gentlemen, may I begin by expressing my utmost appreciation to Yang Arif, Chief Justice of Malaysia, and the members of Judiciary for granting me the honor to address this respected gathering. It is a privilege to be here today as we gather to mark the opening of the legal year for Sabah and Sarawak 2026 on this beautiful land of Borneo, rich in culture, diversity, and history. This annual ceremony stands as a symbol of our collective commitment to the advancement of justice, the strengthening of legal institutions, and the preservation of the rule of law. Ya Arif, ladies and gentlemen, the story of Malaysia's journey is indeed vibrant and colorful, reflecting on the tapestry of history from the moment of our nation achieved independence and the formation of Malaysia. Many then doubted and even questioned, would this nation with Borneo states separated by South China Sea be able to remain strong as a nation state as well as succeed? It is a fact that looking at Malaysia's achievements to date, from the first crawl to subsequent stumbles, the road to success has been full of challenges. It is indeed miraculous that soon after independence, we embraced the system of parliamentary democracy, constitutional monarchy, and federalism. Federal Constitution envisions a balance between national uniformity and local autonomy, one that ensures cooperative engagement among levels of government where responsibilities intersect. The principle of compliance by the federal government and the states to act within their respective constitutional authority is essential for a federation to operate and to avoid encroachment into each other's rights and sovereignty. All parties must duly respect the principle of federalism in order to maintain unity. This is well elaborated by Professor Andrew J. Harding and Professor James Chin as follows. The federal system which has been adopted has its own significant roles in perpetuating democratic ideals in the country and maintaining unity. The leaders especially must have mutual respect and courtesy among themselves and to the people. As role models, the leaders must show great respect to the law and constitution. They must comply with the letter of the law and uphold the spirit and philosophy of the constitution. Yang Ma'arif, ladies and gentlemen, as we commence this legal year, we stand as a pivotal moment shaped by the Madani government's reform agenda. The implementation of the Malaysia Agreement 1963 or MA63 continues to remain as among the top agenda items under the Madani government. The Yang Amat Berhormat Prime Minister has provided assurance that the government would continue to refine matters under MA63 that need to be resolved. The implementation of matters under MA63 is carried out through discussions and negotiations, mainly through the Malaysia Agreement 1963 Implementation Action Council, or MTP-MA63. MTP-MA63 is a forum chaired by the Prime Minister and attended by the Premier of Sarawak, the Chief Minister of Sabah, Federal and Borneo States Ministers, myself, and the Secretary General of the Treasury. Another forum of negotiation established is the Technical Committee of Malaysia Agreement 1963 Implementation Action Council, chaired by the Deputy Prime Minister and Minister of Energy Transition and Water Transformation, and attended by ministers and high-level ministerial officials from federal and the Borneo States government. These two platforms aim to set the direction and policy decision regarding the implementation of MA63 based on the federal constitution, MA63, the Intergovernmental Committee Report 1962 or IGC report, and other applicable laws. Attorney General's Chambers, or AGC, as the principal legal advisor to the government, as stated under Article 145 of the Federal Constitution, holds a significant responsibility of scrutinizing all matters and proposed solutions, taking into account all relevant aspects without prejudice to the established historical facts. The deliberation of all issues in these forums has and must be handled carefully with the highest regard for the rights of the federal government and the Borneo states as stipulated in the Federal Constitution, the supreme law of the land. Yang Ma'arif, ladies and gentlemen, in pursuing legal reforms, AGC has consistently upheld one fundamental principle, that the law must continuously evolve to meet the changing needs of society. A legal system that remains stagnant cannot effectively safeguard the rights of the people, support national development, nor address emerging global challenges. Over the past years, we have undertaken significant efforts to ensure that the constitutional framework of our federal structure remains faithful to its original spirit, while remaining responsive to contemporary needs. Though through the diligent discharge of our constitutional and legal responsibilities, we have achieved several meaningful and notable outcomes, including, first, through the Constitution Amendment Act 2022 amendments were made to Clause 2 of Article 1 and Clause 2 of Article 160 of the Federal Constitution. This amendment seeks to specify all the constituent states of the Federation by restoring, with modification, the position of Clause 2 of Article 1 of the Federal Constitution during the formation of Malaysia in 1963. Second, the transfer of regulatory authority over gas distribution and electricity supply from the federal government to the state of Sabah was effected through Article 95C of the Federal Constitution in 2023 and 2034 respectively. Third, the Labour Ordinance of Sabah Amendments Act 2022 and the Labour Ordinance of Sarawak Amendment Act 2025, both of which came into force on 1st May 2025, further enhanced the minister's authority to formulate rules suited to the specific needs of each state, subject always to the concurrence of the respective state authorities. And lastly, AGC remains committed to ensuring that all Malaysian laws stay relevant and up to date. In line with this commitment and in exercising the revision powers conferred by Revision of Laws Act 1968, AGC diligently and continuously revises pre-1969 laws in Malaysia, including those of Sabah and Sarawak that have been declared as federal law. To date, the AGC has cumulatively revised 295 pre-1969 federal laws, reflecting our sustained efforts to safeguard and bolster the nation's legal framework. Some of the significant legislation revised are the Prevention of Public Security Sabah Act 1962, the Preservation of Public Security Sarawak Act 1962, and the Auctioneers Ordinance Sabah Chapter 9. Among other matters successfully resolved at the negotiation stage and which are currently undergoing careful review by the federal government in consultation with Borneo State Government are, first, the proposal to increase the number of parliamentary seats allocated to representatives from Sabah and Sarawak, and second, the empowerment of state authority in matters related to scheduled waste management, which are currently regulated under the Environmental Quality Act 1974. The implementation of these matters requires extensive and meticulous deliberation, particularly where amendments to the Federal Constitution and related legislation are required. In this regard, AGC, as the legal advisor to the federal government, carries the solemn responsibility of ensuring that all proposed legal reforms are consistent with both the spirit and letter of the Federal Constitution and faithfully reflect the aspiration embodied in MA 63 and the recommendation of the IGC report. In addition, AGC continues to play an active role in facilitating negotiation between the federal government and the state government of Sabah, pursuant to review mandated under Article 112D of the Federal Constitution, following the decision of the Kota Kinabalu High Court in Sabah Law Society against the government of the Federation of Malaysia and the government of State of Sabah. The presiding judge is here with us today. In this regard, both parties are progressing constructively towards a mutually acceptable and sustainable agreement. This development signifies our collective commitment to a cooperative model of federalism, one that emphasizes consultation, mutual respect, and shared responsibility between the Federation and the states. They also reaffirm the second principle of rule of law articulated by constitutional scholar A.V. Dicey, that the law must operate not only uniformly, but also fairly among every person in the Federation, with due regard to the rights and histories of the various communities within the state. Ya Ma'arif, ladies and gentlemen, the government of Malaysia has achieved significant victories in its fight against the baseless claim made by the purported heirs and successors in interest to the Sultan of Sulu in various jurisdictions. Since 2019, we have commenced our battle against these claims in not just Malaysia, but also Spain, France, the Netherlands, and Luxembourg. It has been proven to be a daunting and challenging journey for us, but we managed to succeed as we have always held on to our unwavering faith in the respective justice system. In Spain, for example, in October 2025, we have secured a landmark conviction against the rogue arbitrator, Dr. Gonzalo Stampa, for his utter disregard to the orders of the Spanish courts. Dr. Stampa has been sentenced to 6 months imprisonment and 1 year prohibition from acting as an arbitrator. More recently, in France, on 9 December 2025, the French Court of Appeal has annulled the final award issued by Dr. Stampa on 28 February 2022, as the court found that there is no valid arbitration agreement binding Malaysia. As a result, the final award was annulled in its entirety. AGC will continue its commitment to defend Malaysia's sovereignty, immunity, and national interests against any baseless claims by any individuals or entities. The Madani government remains firmly committed to advancing the legitimate aspiration of Sabah and Sarawak, while ensuring that the unity and integrity of the Federation remain intact. The negotiation between the federal government and the government of Sabah and Sarawak continue to progress constructively. They are expected in due course to culminate in a mutually acceptable and enduring agreement. The matters presently under active discussion include the appointment of judicial commissioners in Sabah and Sarawak, as well as issues relating to the administration of education, health, and the ongoing efforts towards the realization of Borneoization. AGC remains fully committed to providing its unwavering cooperation throughout this deliberation and to furnishing well-considered high-quality legal advice to the federal government before any decision is finalized. This steadfast dedication reflects AGC's deep sense of responsibility in discharging our constitutional mandates in a manner that honors the spirit and intent of the MA 63, while fully upholding the foundational principle of federalism. Ya Ma'arif, Ya Arif, ladies and gentlemen, as we look ahead, let us remain guided by the conviction that our federation, rich in diversity, anchored in constitutionalism, and strengthened by mutual respect, will continue to flourish where each of its components is afforded the space and authority envisioned by our founding documents. The progress we have made together through dialogues, cooperation, and unwavering commitment to justice is a testament to the resilience of our federal structure and the shared aspirations that unite us as Malaysians. With that, as my closing remark, I wish to extend my heartfelt greeting to all members of the legal fraternity and everyone present today, and hope for a year filled with peace and harmony. As a final thought, let us remember the wise words of Tunku Abdul Rahman, Putra Al-Haj, our father of independence, when he addressed the House of Representatives on the Malaysia motion on 12 August 1963. That through Malaysia, and only through Malaysia, can our country and the new state survive the stresses and strains of the modern world. Only through Malaysia can we become a virile and prosperous nation, ensuring peace, stability, and happiness to our people. As expressed in the Kadazan Dusun language, Sunduan Misompuru Kopogowit Kalantayan conveys the meaning, united we stand, divided we fall. Before I end my speech, please allow me to share the following Malay proverb. Malay proverb this time, my lords, my lady. Not Penton. Batang kelapa dipotong-potong, tiap satu tidak disukat. Bola air kerana pembentung, bola manusia kerana muafakat. Jerat semata di hujung tanjung, terkena landak jantan betina. Panjang dikerat, pendek disambung untuk kita bekerjasama. Iri-iri no mantat doho konsiko. Thank you, and I wish everyone a meaningful and rewarding year ahead. Thank you.
Thank you, Tan Sri Muhammad Dusuki. The Right Honourable Chief Justice of Malaysia, the Right Honourable President of the Court of Appeal, the Right Honourable Chief Judge of Malaya, Right Honorable Attorney General of Malaysia, the Honorable Deputy Minister in the Prime Minister Department, Law and Institutional Reforms, Honorable Judges of the Superior Courts and Judicial Commissioners, the Honorable State Attorney General of Sabah, the Honorable State Attorney General of Sarawak, President of the Sabah Law Society, President of the Sarawak Advocates Association, Honorable President of the Malaysian Bar, distinguished guests, ladies and gentlemen. Assalamualaikum warahmatullahi ta'ala wabarakatuh, and a very good morning. Kopi sanangan do kinorikatan id Sabah. Selamat datang ke Sabah, negeri di bawah bayu. Welcome to Sabah, land below the wind. Honored guests, distinguished members of the bench and the bar, ladies and gentlemen, it is my great privilege to welcome you to the opening of the legal year 2026 for Sabah and Sarawak. The presence of so many distinguished members of the judiciary, the legal profession, and our invited guests today stands as a strong testament of our collective commitment to upholding the rule of law and ensuring justice for all. On behalf of the Malaysian judiciary in Sabah and Sarawak, I would like to convey my sincere appreciation to each and every one of you for being with us here in Kota Kinabalu. As we come together to mark the beginning of the new legal year, we do so in the spirit of a proud and enduring tradition, one that not only brings our judicial community closer together, but also to strengthen the foundations that we have entrusted to uphold. With the greatest of respect, allow me to extend a very warm welcome to the Right Honorable Datuk Sri Wan Farid bin Wan Saleh, Chief Justice of Malaysia, the Right Honorable Datuk Abu Bakar Jaiz, President of the Court of Appeal of Malaysia, and the Right Honorable Datuk Hashim bin Hamzah, the Chief Judge of Malaya. We are deeply honored by your presence here today. I would also like to congratulate the Right Honorable Datuk Hashim bin Hamzah on his appointment as a Chief Judge of Malaya. At the same time, I warmly welcome our new judicial commissioners, Justice Tuan Steve Ritikos at the Tawau High Court, Justice Ratana Devi bin Yusuf Perumal at the Kota Kinabalu High Court, and Justice Hamid bin Ismail at the Miri High Court. My heartfelt congratulations to each of you, and I wish you every success as you begin this new chapter in your judicial career. I would also like to extend my heartfelt congratulations to the Attorney General's Chambers of Malaysia, the State Attorney Generals of Sabah and Sarawak, as well as the Presidents of Sabah Law Society and Advocate Association of Sarawak on your achievement over the past year. Your dedication and professionalism have played a significant role in supporting the administration of justice, and I sincerely appreciate the valuable insights and perspective you shared in your addresses today. To our distinguished guests who have traveled from Sarawak, Kuala Lumpur, Putrajaya, Brunei, Singapore, and Hong Kong, I extend our warmest welcome to Kota Kinabalu, and I hope your time here will be both pleasant and enriching, and that you will live with fond and lasting memories of our home. 29th of July 2025 marked a significant milestone for me personally, as I was entrusted with the office of the Chief Judge of Sabah and Sarawak after my predecessor, Yang Berbahagia Tan Sri Datuk Abdul Rahman bin Shibli. And I wish to place on record my sincere appreciation to Tan Sri Abdul Rahman for his leadership, legacy, and contributions to the courts of Sabah and Sarawak. The foundations established under his stewardship will continue to guide our work, and it's now my responsibility to build upon them with diligence, consistency, and integrity. Overview of the court performance for 2025. Allow me to briefly recapitulate the key developments and milestones achieved by the High Court of Sabah and Sarawak throughout 2025. In the past year, the High Court of Sabah successfully disposed more than 2,000 cases out of 3,039 civil cases registered and 534 out of 925 registered criminal cases. The figures included cases carried forward from previous years. For the same period, the High Court of Sarawak had disposed of 3,236 cases out of 4,263 registered of civil cases and 333 out of 776 registered criminal cases. In the Session Court of Sabah, 2,660 out of 3,459 registered civil cases and 7,000 out of 8,000 registered criminal cases were disposed last year. Similarly, the Session Court has recorded the disposal of 2,554 out of 3,645 registered cases in Sarawak and 5,346 out of 6,209 registered criminal cases. The Magistrate Courts of Sabah recorded disposal of 9,645 out of 11,530 registered civil cases and 21,855 out of 26,164 registered criminal cases. Likewise, the Magistrate Court of Sarawak has recorded the disposal of 7,598 out of 9,177 registered civil cases and 16,651 out of 20,839 registered criminal cases. With the statistics reflect steady progress and improved efficiency, certain delays remain inevitable due to the factors such as availability of witnesses, expert reports, complexity of the evidence, and the schedules of the parties involved. Addressing these challenges demands continued vigilance, strategic case management, and the adoption of innovative solutions, including pre-trial conferences and alternative dispute resolution. For this purpose, and in view of the increasing administrative workload in the CJSS office, another milestone for 2026 is the appointment of managing judges for Sabah and Sarawak. Justice Rosaria Bujang has been appointed as a managing judge for Sarawak, while Justice Azahari Kamal Ramli assumes the role for Sabah. With the extensive experience as High Court judges in Sabah and Sarawak, coupled with their tenure as appellate judges, I am confident that they will further strengthen judicial administration. In their capacity as managing judges, they will oversee judicial performance from an administrative perspective by monitoring key indicators such as case disposal rates, backlog levels, and the timeliness of delivery of grounds of judgment, while identifying systemic delays or performance issues in the Magistrate Court, Session Court, and the High Court. In my capacity as a Chief Judge, I remain firmly committed to supporting the judiciary in meeting these challenges with a constant focus on minimizing delays while upholding fairness, due process, and the highest standards of judicial decision-making. On a personal note, the exemplary performance of the court in Sabah and Sarawak stands as a testament to the resilience, dedication, and professionalism of all who serve within the judicial system. It reaffirms our steadfast commitment to maintaining public confidence and safeguarding access to justice. While the figures are significant, they capture only part of the story. Behind them lies the unwavering dedication of the judges, judicial officers, and court staff, whose tireless efforts ensure that the administration of justice continue to operate smoothly and efficiently throughout our state. To each and every one of you, I extend my sincere and heartfelt gratitude. Court achievements in 2025 and the plans for 2026. In 2025, our work reminded us of a simple but powerful truth. Justice is not about cases and courts, it is about people. It is about communities. It is about the world that we share. Through our initiative last year, we sought to bring justice closer to the people, support those in need, and to respond to the societal and environmental challenges that touch our daily lives. These efforts are not measured by numbers alone. They are measured by lives touched, confidence restored, and hope renewed. As we look ahead to 2026, we carry this mission forward with renewed purpose. We will continue to expand these programs, making justice more accessible, oversight more effective, and initiatives more meaningful. And in every step, our goal remains clear: to serve the people, strengthen our communities, and protect the environment that we all depend on. Mobile courts bringing justice to the people. Sabah's vast rural areas and remote communities have long made access to justice and government services difficult. Many villagers face long, challenging journeys to reach the nearest court or department. A key impact of this is delayed registrations of birth and death, which often requires judicial inquiry to ensure the facts are properly recorded and admissible in evidence. In 2007, the mobile court program was born so that justice could reach those who live far from the city, in villages where the nearest court may be days away. Judges travel by land and river, bringing the law directly to the people, supported by legal, medical, and governmental teams. They hear cases on site, ensuring that even the most remote communities are not left behind. Over the years, the program has grown. Mobile court buses now reach rural towns, and since 2019, the urban mobile court has served communities moving into our cities. In 2025, the mobile court continued to bring justice directly to the people, reaching rural interiors, coastal villages, and selected urban areas across Sabah. 17 sittings were held, resolving 1,274 cases, mostly late birth registrations, traffic offenses, and other matters requiring judicial inquiry. These proceedings gave people timely access to their rights while also easing the workload of our permanent courts. The mobile court is more than just a program, it is a lifeline, reflecting our commitment to making justice accessible to all. Since taking office last year, I very much look forward to be participating in such activities in 2026. And in recognition of its pioneering role, the Mobile Court Gallery has been created to celebrate the history and evolution of this program in Sabah. It will serve to educate the public about the judiciary commitment to bring justice to marginalized and remote communities, while paying tribute to the tireless dedication of our judges, court staff, and partner agencies who have made this vision a reality. Through its exhibit, photos, stories, and archival materials, the Mobile Court Gallery brings to life the program's vital role in advancing social justice, promoting inclusivity, and safeguarding fundamental rights. On that note, I wish to express my sincere gratitude to Yang Ma'arif, Chief Justice, for graciously agreeing to inaugurate the Mobile Court Gallery at the Kota Kinabalu Court tomorrow. It will truly be a landmark moment celebrating Sabah's dedication to transparency, public legal education, and meaningful judicial outreach. Mobile court for children. Another matter of importance is the implementation of the Mobile Court for Children pursuant to the Arahan Amalan Ketua Hakim Negara No. 1 of 2025. The Arahan Amalan entails three components for the Mobile Court for Children, namely, Vehicle for Meaningful Redress, VMR, that is a vehicle used to bring victims and or witnesses from their homes or temporary residence to the court. Second is Victim Nexus to Justice, VNEJ, that is vehicle modified as a room for witnesses and victims to give their testimonies. And thirdly, Victim for Nationwide Justice, VNJ, a vehicle modified as a mobile courtroom. While our current mobile courts have been converted as VMR and VNJ, the VNEJ component has yet to be incorporated. It is our hope that Sabah and Sarawak will be fully equipped with the complete facilities of mobile court for children to enjoy the full implementation of the initiative. The implementation of the mobile court for children marks an essential reform designed to bring justice to its most vulnerable participants. By conducting proceedings in a familiar and less intimidating environment, the mobile court mitigates the psychological distress often experienced by child witnesses and victims in conventional court sittings. Caring for our environment. In keeping with our dedication to serving the public, the judiciary has played a pivotal role in championing environmental justice across Sabah and Sarawak. In Sabah, this vision is realized through 3 working groups in Kota Kinabalu, Sandakan, and Tawau, reflecting a decentralized approach that responds to local communities. In Sarawak, a state-level working group carries forward the same mission. Together, this effort demonstrates our commitment to justice, not only in the courtroom, but also for our environment and future generations. Since its inception, the working group has led the way in environmental justice, strengthening judicial capacity, shaping policy, and engaging communities. Its works extend beyond the courtroom, including the initiatives such as cleaning up of Kampung Sembulan, the 1 million trees planting project, marine and coral restoration, and forest conservation programs. The working group has strengthened environmental law through sentencing guidelines for wildlife and forest crimes and fostered regional dialogue through the Borneo Colloquium, addressing critical issues like climate change and climate justice. Through strong leaderships and close collaboration with government agencies, NGOs, and local communities, it has embedded environmental stewardship within the judiciary, reinforcing the rule of law and protecting Sabah and Sarawak natural heritage for generations to come. A significant milestone was achieved in 2025 with the 5th Borneo Colloquium on Environmental Justice held on the 4th to the 5th of December in Kota Kinabalu, which celebrated a decade of dedication by the Kota Kinabalu Court Working Group on Environment. Apart from celebrating this decade-long commitment, the colloquium also concluded the proposed definition of climate justice to be presented to the Chief Justice. This achievement was in direct response to the Cebu Declaration adopted by the Council of ASEAN Chief Justice, SICC, in November 2024, which formally established the Working Group on the Climate Justice, WGCJ, recognizing climate change as a regional judicial concern requiring a coordinated collective response. The Wildlife Crime Sentencing Guidelines Calculator for Sabah and Sarawak Courts, the WALCAL. The Sentencing Guidelines Calculator, known as WALCAL, was launched on 24th of April 2024. It was developed and integrated into the e-Kehakiman Sabah and Sarawak EKSS system, drawing on the existing sentencing guidelines for wildlife crimes in Sabah and Sarawak, which were introduced in 2019 and 2022, respectively. Over the years, the courts in Sabah and Sarawak have successfully applied the sentencing guidelines, leading greater consistency in fines and penalties and enhanced judicial confidence in decision-making. The use of WALCAL has also streamlined case management, reduced delays, and supported judicial officers in applying the law more effectively. This year, the Sabah and the Sarawak Working Groups on Environment, in collaboration with WWF Malaysia, will undertake a review of the sentencing guideline for wildlife crimes in Sabah and Sarawak. Following consultations with the relevant stakeholders, WALCAL will be updated to reflect the revised guidelines. Upon completion of the data collection at the end of 2026, elements of artificial intelligence will be incorporated into the sentencing guidelines calculator for wildlife crimes in 2027. A Court of Appeal circuit sitting. In his opening of the legal year 2026 speech, Yang Ahmad Arif, the Chief Justice, highlighted the reintroduction of circuit sittings is intended to ensure that access to justice is not constrained by geography and to provide opportunities for professional growth within the legal community, especially for the young and aspiring advocates. To support these goals, plans are underway for a Court of Appeal circuit sitting in Miri, Sarawak, tentatively scheduled for April, and another in Tawau in the last quarter of this year. My sincere appreciation to Yang Ahmad Arif, Chief Justice, and Yang Ahmad Arif, President of the Court of Appeal. The new court building. In his speech, Yang Ahmad Arif, Chief Justice, has also emphasized the importance of establishing additional courthouses to enhance access to justice for rural communities. In line with this, the new Tenam Court in Sabah will be inaugurated tomorrow, while the Mukah Court in Sarawak is tentatively scheduled to open in April this year. The administration of justice and the way forward. As we enter the legal year 2026, the Court of Sabah and Sarawak remain committed to strengthening the administration of justice. Our focus will be on improving case management, enhancing court processes, and ensuring consistency in judicial outcome. Above all, we remain guided by the principle that efficiency must never come at the expense of fairness, and that progress must be grounded on integrity and stability within the judicial system. On a personal note, I urge all judges, judicial commissioners, and judicial officers to take a proactive approach in managing cases, ensuring that hearings proceed smoothly and efficiently. Judges and judicial officers play a crucial role in overseeing cases from start to finish. Effective pre-trial management, realistic timelines, and firm oversight of proceedings are essential for the fair and timely disposal of justice. When applied consistently, these measures improve access to justice, conserve judicial resources, and reinforce public confidence in our court. Speaking about public confidence is the cornerstone of a strong and effective judiciary. Access to justice is not measured merely by the presence of courts or the disposal of cases. It is fundamentally about the trust that the public places in the fairness, transparency, and integrity of judicial processes. Judges and court officers carry the solemn responsibility to administer justice impartially, free from any external influence, ensuring that every decision is grounded strictly in law. I would therefore encourage judges, judicial commissioners, judicial officers, and legal practitioners to stay informed of the latest developments in the law. For the courts, I look forward to the introduction of additional courses and training programs for judges, judicial commissioners, and officers in Sabah and Sarawak. With the forthcoming establishment of the Judicial Academy, we can anticipate a more structured and comprehensive approach to judicial training. Likewise, members of the bar, particularly young practitioners, should seek to strengthen their practical legal knowledge, uphold the highest standards of professionalism, and approach every matter with diligence. It is vital to remember that your responsibility extends beyond advocacy. Above all, you are tasked with assisting the court in the fair and impartial administration of justice. At the same time, I will continue to promote and strengthen collaborative engagement with institutions such as the Borneo International Center for Arbitration and Mediation, the ASEAN International Arbitration Center, the Malaysian International Mediation Center, as well as newly established bodies, including the Sarawak Institute of Arbitration and Dispute Resolution. Collectively, these initiatives not only enhance the professional expertise of our judiciary, but also contribute to a more robust and interconnected legal ecosystem. Before I conclude, I would like to sincerely thank all the judges, judicial officers, court staff and members of the legal profession for your dedication and service. Today reminds us that the administration of justice is a shared effort. Every one of us, the judge, the officers, the bar, and the court staff, play a role in maintaining a system that serves the people and upholds the rule of law. It is our collective commitment, cooperation, and professionalism that strengthen justice and maintain public confidence in the courts. I would like to extend my heartfelt gratitude to everyone who made this morning event possible. My deepest thanks go to the organizing committee, led by the Registrar of the High Court of Sabah and Sarawak, Yang Berusaha Tuan Nixon Kennedy Kumbong, Registrar of the Subordinate Courts, Puan Dayang Eileen Narisa bin Abang Ahmad, a Director of the Sabah State Courts, Yang Berusaha Puan Azrina Aziz, whose dedication, meticulous planning, and tireless efforts behind the scene have made this event both meaningful and memorable. I am equally grateful to Yang Berbahagia Datuk Zamri bin Bakar, Chief Registrar of the Federal Court of Malaysia, and his deputy, Yang Berusaha Tuan Ashanite bin Azmante, for their invaluable guidance and support. Your contributions are deeply appreciated. As we tap into 2026, let us do so with renewed determination to uphold the rule of law and to deliver justice and with fairness, efficiency, and integrity. Let us face the challenges ahead with courage, carry out the responsibilities of our officers with diligence, and uphold the values of court profession with unwavering commitment. On behalf of the courts of Sabah and Sarawak, I wish you and your families a year filled with excellent health, peace, fulfillment, and joy. And though the year is already underway, it is never too late to wish you a very happy new year. And with that, I hereby declare the legal year 2026 for Sabah and Sarawak officially open.
For generations, justice has stood firm in the courts of Sabah and Sarawak, steady through change, unshaken by time. Across the decades, justice has been upheld by leaders of wisdom and integrity, chief justices who served with honor, shaping a judiciary that is respected, trusted, and strong. Their legacy endures. In every decision that protects fairness, and every judgment delivered in the name of justice. They paved the way for a judiciary that evolves with time, yet remains rooted in principle. With every challenge faced and every reform embraced, our courts continue to rise in service of the people. Their contributions remind us of the enduring spirit and dedication that uphold justice for all. Today, that legacy continues in courts that grow with the nation. For the first time in our nation's history, the Chief Judge of Sabah and Sarawak, is a lady. The Right Honorable Datuk Haja Aziza binti Haji Nawawi. This year, we are proud to witness a historic moment under the guidance of our new Chief Judge of Sabah and Sarawak. And now, as we begin this legal year, we unveil a reminder of the principles that must guide every court, every hearing, and every decision. This unveiling is more than a ceremony. It is a celebration of justice, of leadership, and of the promise to serve the people faithfully in the year to come. As the cloth is lifted, let this moment remind us all of our shared duty to uphold justice, to serve the people with dedication, and to embrace the reforms and challenges that lie ahead in this new legal year. Under the vigilant gaze of our Sabah and Sarawak highest judicial authority, this statue stands as a symbol of the ideals we uphold, a living reminder of the balance, fairness, and integrity that guide every ruling in our courts.
All rise.
Announcing the departure of the Right Honorable the Chief Justice of Malaysia, the Right Honorable the President of Court of Appeal of Malaysia, the Right Honorable the Chief Judge of Sabah and Sarawak, and the Right Honorable the Chief Judge of Malaya. The Honorable High Court Judges and Judicial Commissioners of the High Court of Sabah and Sarawak. The judges of the Federal Court, the judges of the Court of Appeal, and distinguished guests seated in the front row. the Chief Registrar and Registrars of the Court. And the court orderlies. Distinguished guests, ladies and gentlemen, we warmly invite you to Sipadan Hall 1 for refreshment. And for information, table number 1 to table number 8 are reserved for VVIPs, and table number 9 until 59 are free sittings. Thank you and all the best for the year of 20 and 26. Thank you, everyone.